Thank you. Thank you for being here, Makan. At the very introduction of today, I introduced you already to the audience as, I think, singularly the individual who may ultimately be responsible for deciding how those headlines ultimately play out about big tech and where we are. And it feels like we are in a moment, and antitrust has become a not just talking point, but a real issue in America, as you know so very well. My mother is here. My father is an antitrust litigator, so I grew up my whole life sitting around the dinner table talking about whether Microsoft should be broken up and what should happen to various companies. So it is thrilling to have this conversation, and a privilege for you to be here. Here's where I want to start the conversation. Chris Hughes is also here today, co-founder of Facebook, and he wrote this in the New York Times, and I just want to get your thoughts on this. He said, in the past 20 years, this is not just about Facebook, he says, in the past 20 years, more than 75% of American industries, from airlines to pharmaceuticals, have experienced increased concentration, and the average size of public companies has tripled. The results are a decline in entrepreneurship, stalled productivity growth, and higher prices and fewer choices for consumers. Do you agree with that?
Well, I think two things. First, let me thank you for inviting me to be here. And your father's one of the best antitrust lawyers in the country for many years. With concentration, so there's two ways to look at concentration. There's industry concentration. There was a 2016 report that Furman and others had put out about and looking at general metrics of industries. And then there's antitrust markets. And what we look at are specific economic markets that has rigorous tests. Right. We have not seen the evidence necessarily in the antitrust markets for product markets. But of course, I think it's hard to deny that there's been a lot of transactions. A lot of times the transactions can be very pro-competitive for the consumers. You know, you're either eliminating certain margins when you're combining different parts of the supply chain, or you're creating, greater scale to be able to be more competitive. Our job is to look at the antitrust markets and ultimately decide if there's been too much concentration.
So let's talk about big tech, because that's where so much of this exists today. You have announced, it's quite public, that there's an investigation going on into many of these big tech companies. I know you can't talk about specific companies, but just tell us the state of these investigations. Where are you?
So some of the investigations are further along than some of the others. As you know, we announced, I believe it was in July, our review in this field. I think one of the companies has, through their SEC disclosures, has announced that we have sent them civil investigative demands, and there is an existence of an investigation. We have met with, a number of complainants, a lot of
complainants
academics.
Being competitive companies.
Sometimes competitive, sometimes customers, sometimes folks who tried to enter but failed. And so we have been meeting with a lot of folks who have an interest. Now, it's our job, and it's a difficult job, to separate those who have tried and failed for other reasons as competitors, as opposed to a harm to competition that has removed the incentive for somebody to enter in.
Let me ask you a question. You have said big is not bad unto itself. And if I told you that there was a company that had an 80% market share in something, but did it, and let's call it legally, let's say they got there legally, and they're not only do they get there legally, they're not using their power to maintain their monopoly illegally either. Do you think for society that's still a good thing or an okay thing?
It could be okay as long as the barriers to entry into that space still remain. And what they're doing to remain big is to innovate, provide better products, better choices to consumers.
What happens if there's no barrier? I mean, there's no additional barrier except that there's a company that has 80% market share.
Just to pick a number and a company out of
thin air.
No couple of them that you have in mind.
Hypothetically. I know you won't talk about specific companies, so I thought I'd try.
Yeah, no, look, that's an important question. And a big part is, and there's been allegations out there from complainants and others, is have they gotten big through certain activities that may not be kosher, or are maintaining that monopoly? And that was the big issue in Microsoft. Right. So that is going to be our It's a big task, and that is going to be our job to decide that. Now, whether antitrust ultimately is the solution, and I believe it's an important tool, our job is to make sure the markets are free. But there could be policy reasons, and when markets have failed, Congress has stepped in and created these regulatory agencies. I hope we don't go there. Regulation should be an option of last resort in our economy, but hopefully antitrust will be able to address any anti-competitive harms.
Let me ask you a question in this age of technology, and this goes, by the way, and we're going to talk to Bill Gates later today, because the Microsoft Netscape case is a classic example of this. But so much of technology today is about integrating products. And so, you have Apple coming out, or just this last week, with their Apple TV service, and there's been evidence that some of their apps over the years have been advantaged on their iTunes platform or on their App Store over competitive apps, if you will. What's the right answer? And you can take Apple out of it, because I know you probably don't want to go there, but let's say I am company X, and I have a quote-unquote platform, and there are people who are going to sell other things on my platform, but I also sell competitive products. How does it have to work to be legal?
Well, to be legal is a complex question, and I don't want to take away many lawyers' rights to earn a lot of billable hours to do that. I'll leave it to them. I'll tell you what could be illegal instead, and it is when you take action. For example, one indicia of anti-competitive activity could be, you cut off a competitor from an input that they have been receiving, and it makes no economic sense other than to reduce competition. That's the no economic sense test that we have posed, and we will see if that is. But, I'm aware of Spotify's complaint in the European Commission.
This is about Apple Pay, specifically, about how you actually pay for the service using Apple Pay and the 30% that they take.
Right. And so, and there's been private action, all the way up to the Supreme Court for a technical side just last year, in a 5-4 decision. The court said the lawsuit can move forward. So there might be more activity just on the private side here without commenting on what we're doing.
What do you make of the idea of, though, these quote-unquote platforms? And by the way, it could be even large retailers. Amazon would be one in the digital space, but you could think about this at Walmart as well, which is Amazon or Walmart sees that batteries are selling really well, and maybe we should white label batteries. And this has been going on for all of time. But when you get to a place where all of a sudden the retailer, if you will, or the platform is now selling a product, by the way, using potentially some of the data, or at least to understand the market, to then compete against those people on the platform. This, by the way, is true of Google. Barry Diller, who's been at this very conference many times, has commented that his company Expedia pays billions of dollars annually in terms of advertising dollars to Google. And now Google, over the past couple of years, now if you type in an airline flight, they have their own service. And what that mix is supposed to look like.
There's a lot packed in that question, but I think at the core of it gets to data and how, a lot of these companies, how they operate and the information they're getting from, let's say, that seller that was on that platform is the type of data that might be very important. There's no question that as part of our review in the Federal Trade Commission and the European Commission and others, we are examining the role of data. Data is an asset for companies. In and of itself is not anti-competitive, but just like any other asset can give you market power, data can give you market power, and its abuse would be a violation of antitrust law. So we would have to take a look. Sometimes the use of that data, the collection and use, could violate the promise the company made to that customer or that business partner, and that could be the the unfair competition and consumer protection that the Federal Trade Commission enforces, which they recently did in Facebook.
If you were in office back when Joel Klein was in your role, would you brought the case against Microsoft?
So I left private practice to go work in the Senate Judiciary Committee as the Antitrust Counsel as a young attorney to help Orrin Hatch with those hearings in there. I don't think, there was a lot of political activity back then trying to cut off the Antitrust Division's funding that Orrin Hatch, as the Republican chairman, protected. So I think that will tell you where I was and where the chairman was on that. I absolutely, I think that was a case to bring. And look, and the important thing of that, there was a lot of debate that was wrong-headed. A unanimous DC Circuit Court of Appeals, led by then Chairman Doug Ginsburg, who had my job in the Reagan administration, ruled that they violated the law.
Let me ask you another question about just where we are, which is, for so long, antitrust has been looked upon, or at least these transactions have been looked upon about the price it's going to cost the consumer, right? And in so many of these spaces, it's either brought costs down, or it's been free to the consumer. However, nothing's free.
Nothing's free
in life. And so, do you think there needs to be a different language around the world of antitrust today?
So I think the consumer is, and I think we're seeing a little bit of a change. People are a little bit more, and a lot of that is the congressional hearings and some public attention paid to this. I think more and more consumers are concerned about what is happening with their data. You know, are these companies creating a digital voodoo doll of us? And not so much because of what we have done, but try to predict what we will do, which seems a bit creepy. And that gets into other policy issues. I think what we need to take a look at is, does the consumer have the choice? Will the consumer have the ability to move around? There is nothing that is free. If consumers think they're getting any service for free, you know, they're being misled.
So I have an interesting one for you. Facebook, one of the leaders of Facebook was recently asked whether they'd ever do a paid service at the company. And they said no. What does that say to you?
Well, I think it depends on when in time. There was, some studies, and again, 10 years ago, a consumer may have a different view than they do today or 10 years from now. And, there's a great economist at the University of Chicago, Samuelson, who I think won a Nobel Prize for the theory of revealed preference. Right. And I think as time goes on, consumers will determine whether or not they have the choice to move around. And that, in and of itself, will create a market that we can evaluate. I'm not on Facebook. My wife spends enough time on that for all of us in the family. But I would probably join a Facebook type if I would pay, I'd be happy to pay $5 a month.
What do you make of the privacy issue, the free speech issue that seems to be a cloud, or at least involved in this? And I don't know if you think that they are connected or not, but when it comes to big tech, that seems to be part of this. We're going to talk, I see David Marcus here, we're going to talk about that a little bit later at Facebook. But when you think about privacy, when you think about free speech, and I'm, by the way, thinking there was an op-ed in the New York Times by Tim Wu, who I think is also here from Columbia, who said the nation's dominant social network is creating the kind of monopoly influence over politics that the framers of the Sherman antitrust law were concerned about by refusing to stay out, meaning this is on the political paid ads issue. Facebook is in effect building the case for its own breakup. I know you can't speak, again, directly to the company, but you're seeing this, and this is across the board of all sorts of different companies in the technology landscape.
So how it starts playing into the antitrust prism is that, choice, the consumer's choice, or the quality of the service. Does a company's market power prevent the choice of different qualities that a consumer would want? So that's how it would. Otherwise, I think privacy and others, we have a number of regimes out there, and Congress and White House and others are debating, should we have a general regime for data privacy? We have so many rules for privacy already in this country, financial privacy, healthcare privacy, driver's license privacy, but should we have that for this? And I think that's one that should be reserved for a public, but it can play if you're limiting quality or choice to the consumer.
I have a different question, and it's a political question for you. You have talked...
I haven't been getting into those lately.
You have talked a lot about how you don't like and don't think that, don't want the public to have perceptions of your office being political. That it creates a mistrust if they believe your office is political. And yet, as you know so very well, there has been a lot of questions and skepticism around some of the mergers that have been approved or not approved, as a relation to your boss, President Trump. This was true, at least, of AT&T and Time Warner, and then people looked at that and juxtaposed it against the Fox-Disney deal. I want to read you just for a second. Joe Nocera, my former colleague here at the New York Times, who's now at Bloomberg, wrote the following. He said, "The rule of law is such a bedrock principle in the U.S. Until Trump came along, it was part of the air we breathed and the water we drank. We barely ever had to think about it. Trying to involve himself in antitrust decisions," this is Trump making proclamations about many of these deals publicly, "is one of 100 ways this president is eroding our faith in the rule of law. Not knowing if we can count on it is disorienting. It makes it difficult to even have a discussion about Amazon's dominance because of the fear that any such discussion will be hijacked and corrupted by the president." What do you think of that?
I think Joe has the First Amendment right to write anything he wants as his opinion. I think he's wrong, and let me explain why. Look, these debates have gone on for some time. The previous administration, I think it was reported at least half every other page of a staff memo in Google done at the Federal Trade Commission that had recommended bringing a lawsuit. There was a lot of discussion back then. Maybe it wasn't as popular to criticize the president. There was a lot of discussion that over 40 Google executives were in the Obama administration, and the political leadership did not bring that case because of that. Now, AT&T put that on steroids when the AT&T Time Warner transaction was challenged, or parts of that. And I think folks, and that was a strategy. That was a public relations strategy, and I get that.
Randall Stevens was here, right, when you were in the middle of that case, and we talked about that.
And to his credit, he mentioned that I never, or nobody at Justice, had recommended him or demanding that he would sell CNN. In fact, when he offered it to sell as part of a settlement, I rejected it. Our issue was really with TBS, TNT, and the others because sports rights were locked up till, I think, 2030 or so, thanks to a great executive, Levy, that they used to have there. But look, all they had to do was take a look at what our arguments were, and it would fall on its face. I remember writing a letter to the Oscars when last year they were going to change the rules to prevent, like a movie like The Irishman today,
right.
Netflix or an Amazon movie.
Reed Hastings thanks you for that letter that you sent to the Oscars.
Well, and he was very clear that he never asked me to send that. That's what we do. We read the papers, and sometimes we'll inquire. And we wrote that if you change these rules, you better be cautious of the antitrust laws. Well, there was a whole 15-minute segment on one of the channels that said that why that was done for political reasons, because the president hates Hollywood or something.
Do you ever talk to the president?
Yes.
You do?
Yes, not any specific matters
Does he
us.
call you about this stuff?
No, we have very strict rules between communications between the White House and the Justice Department. But let me tell you, just finishing that, is all you have to look is who that letter benefited.
Right.
Who are there? Amazon, Jeff Bezos, and Netflix, Ted Sarandos and Reed Hastings. You tell me if they're the fans or the patrons of the president.
Right.
And I get it.
Right.
It sells.
I want to go back to these conversations with the president. How are we to believe, and I ask you this genuinely, that the president is not trying to influence you on these issues? And the reason I say that is, you can even look on Amazon. Obviously, not only is he out there publicly declaring war oftentimes on Jeff Bezos, but there was a book recently written, one of the speechwriters for Mattis, who said that the president literally called up Mattis and said, we got to figure out a way to screw Amazon and make sure they don't get this Pentagon deal. And so how, I mean, to the extent you don't want the office to be politicized, how do you protect it?
Well, we do what we do. Look, we have to, we're the law enforcement agency.
Right.
At the end, we have to go to court. It is all transparent what we do. And AT&T, they demanded my communications with everybody in the White House. They got all of that. What they didn't get, the judge put a stop to, was White House communications with the Bureau of Prisons and the Environment Division and everything else they wanted. Now, look, there's checks and balances in place. There's Congress that oversees us. There are specific rules that have existed since Judge Mukasey was the Attorney General. Eric Holder, we still operate under the Holder memo about how you communicate with the White House. When I was in the White House counsel's office, Don McGahn issued a new rule about who can communicate with the Justice Department.
He's never asked you, though, anything about these deals that are in front of you?
Never when a deal has been pending have I discussed a matter.
Let me ask you a different question. Would you
president.
prefer that he doesn't say
this.
stuff publicly?
Look, no, the President of the United States has the right, just like any other citizen, and you know, to
But it would make your life a lot easier if he didn't.
It could, but you don't take these jobs because my life is easier. But look, Senator Warren,
Right.
Senator Blumenthal, they write to me almost on a daily basis about every transaction. Who should not have the right to comment? And now it's our job to make sure that we don't, like AT&T Time Warner, I think I had 19 Democratic senators at the same time that discussed that while it was pending. So look, our job is to make sure that it is, now I can't control what folks write and get clicks for.
I have a different one for you, though. So, and you had to answer this from Senator Leahy. And I'm curious, again, this goes back to the public trust issue. So you know what hotel is across the street from your office?
Yeah.
The Trump Hotel
Right.
in Washington.
A block away.
And a lot of executives have said to me straight up and down, we stay there in large part because not only is it convenient, but on the margins, if somebody in the administration asks us where we stayed, we like to be able to say we stayed at the Trump Hotel. Would you prefer that they don't stay at the Trump Hotel?
Look, I would prefer that they don't stay at any hotel because they think it influences a law enforcement official or a regulator. That would be wrong. But when Senator Leahy asked me, said, they came there. I don't know. It was reported in the Washington Post. They'd spent a couple $100,000.
These are the executives from Sprint and T-Mobile.
And T-Mobile. And of course, because of that, that's what. I said, why? I go, I don't know. You have to go ask them why they stayed there. I could take a guess. It's 1 block away from Justice.
So wouldn't you prefer that they don't?
I will leave it to them. Look, it's a phenomenal hotel. It's got a great restaurant in there. I have been there because it's really a block, a question, 1 block away. I don't recommend it to folks who might be offended of going there, but that's a free choice. And again, it's a great hotel. I think people love to make things out of absolutely nothing.
Okay, I have 2 more questions, and then I know I want to get to Chris and so many other people in this audience. The NCAA sports recently announced that.
Before you get that, can I also say,
please.
We have not changed our merger forms to ask people where they golf or where they're staying at their hotels. That is just, that whole idea is just silly. And, I hope people don't think and write about that.
Okay, so here's my 2 final questions.
Yeah.
One has to do with the NCAA changing their rules around paying or at least allowing sponsorship of athletes. There's been a huge issue around sports and antitrust and whether these leagues are cartels to begin with. What do you think of this change, and are you going to be writing any letters to anybody soon?
So the NCAA threatened California when they passed the legislation that they would boycott the California schools. I'm an old UCLA Bruin, so I had a real interest in this thing. And I thought that as a horizontal, organization of a number of competing universities, if they actually engage in the cartel, that would be a real problem. And I let those views be known. I was heartened that they are going to change the rules to allow for that. But they said they're going to begin the change of the rules process consistent with rules of amateurism. And we would have to take a look. Are they going to be limiting competition? I think what California did on a unanimous basis, and I give credit to Gavin Newsom for that, is I think it changed the dynamics. And NCAA is I think, stranger to the antitrust laws over the years.
Let's open it up for questions. I wanted to get to Chris Hughes because you have made such news recently. And I'm curious, I would ask you, Chris, but also if you have if you want to throw one back to Makan as well, whether you think this has gone far enough, not just in the world of technology, but I know that you've been thinking a lot about the broader antitrust landscape.
Well, it's actually the question also that I have for Makan. Nice to see you. Thanks for having all of us here today.
Have you guys been meeting in private, by the way? Can I
as has been reported, we have not. I was invited in to talk to the FTC, and we had one conversation over the summer, which was really helpful, and at least to me, I hope it was helpful to you guys. But my question that I came away from your comments today, that conversation, and a lot of other remarks that you've given is around price and around cost. A few years ago, people said there's no way you can think about antitrust scrutiny of Facebook or Google because they're free. They don't cost anything to people. And now it seems like we're in a different era. And even, the question today suggests that we're hearkening back to a time when antitrust was about a lot of things, about competition, how it affects producers, consumers, investors, the community, and how the political and economic power affects our democracy. So I wonder if you would characterize this as a shift in the field, a step forward, and specifically how tech complicates the conversation around price.
Sure. So, as far as a shift in the law, it is not a shift in some attention to factors other than price. It probably is. Part of that is because a lot of cases, it's easy to quantify, and a lot of the economic analysis that has grown around antitrust focuses in on the price effects of any transaction. But look, for 40, 50 years or however long, we've had broadcast television. Is that free? It's technically free to the consumer. But somebody is paying for that, and we have looked at mergers, some of the best antitrust cases, the ABC and others, and we just had a big enforcement action into a lot of, I think 7 broadcasters who were sharing information about advertising capacity. So there's a lot of antitrust activity around products that are ultimately free. That was a big argument in Microsoft as well. They were giving away the internet browser, the Internet Explorer, for free. So how could it be a violation of antitrust? The antitrust laws recognize a number of factors that could be indicia of a violation: price, quantity, quality, choice, innovation. And those are all factors that we're looking at, and the burden is on us to challenge ourselves to not just take the easy route and only enforce in areas where there's a price effect, but take a look and develop the theories consistent with the law.
I have a final...
Thank you for your input.
Is Noah Phillips here from the FTC?
Looks like he's
I don't know. There he is. I have a question for you, but also maybe you guys can get together on this in front of the audience, because you come at this from 2 different places, and maybe you have a question for him. But I wanted to know, how do you think we're going to be seeing Kevin Systrom from Instagram in a little bit? How do you think about big companies today that then buy small companies? At the time when they buy the small company, unclear whether they're ever going to succeed, right? This is sort of the case with Instagram. But the reason I ask the question is because now we're looking at these types of transactions and whether you think the rules should change about what a big company can even buy today, even if it's a little minnow over here right now.
I don't know that the rules need to change, but consistent with what the Assistant Attorney General just said, I think there's a change in focus. I think that all of us as antitrust enforcers, we follow the research, we follow the media, and when we hear about a transaction, maybe of a small company, but maybe with the potential for growth, we're focused on these kinds of questions. Part of the challenge, I will say, is that if we want to block a deal, if we have reason to believe that a deal is anti-competitive, we don't just press a button, right? We don't just vote. We have to go to court, which means we have to convince a judge, and we have to use evidence to do that. And judges can sometimes be skeptical of the evidence that we adduce. But I think the big change, at least for me, is that we are thinking about this issue and trying to look at companies through additional lenses than maybe we were before.
Do you guys think you're working well together? Because I think you guys compete at some level. Do you like that competition?
I think there's a great old FTC commissioner who said, competition is fantastic in all places except for the enforcement of competition. Look, we've had a history of working well. We worked really well together recently at a Senate hearing with the chairman, Joe Simons. I said, look, most of the press write about the plane crashes, not the safe landings. There's a hell of a lot more safe landings for every crash. And, it's interesting to write. We have clashes every now and then. Look, if we were going to design the government system for antitrust enforcement today, would we have 52 enforcement agencies in one country? Two at the federal, every state AG? Probably not. And at some time, maybe Congress should take a look at, does this all make sense?
Final question from me, and it is close to home. I'm curious how you feel about the government using its power over companies. And when I said it's close to home, here it is. As you know, President Trump has directed all government agencies to cancel their subscriptions to the New York Times and to the Washington Post, and I want to know whether you think there's a good restraint of trade case to be made.
You know, it's a great question. I'll leave it to your lawyers to decide if there's a cause of action against the federal government as a purchaser.